saying that that is a distinction that doesn't make a difference to most of the people watching television. You are exactly correct. What we are reauthorizing this fall has nothing to do with what we are discussing, other than it is another government program where the people consent to allow government to pursue certain things with the explicit promise it will be protected. So you're right, they're different. But in the eyes of people watching, it is the U.S. government officials leaking the name of a U.S. citizen, and if it can happen here, it may happen there. Trust me, you and I both want to see it reauthorized. It is in jeopardy if we don't get this resolved.
Mr. Gowdy is recognized.
Thank you, Mr. Chairman. Director Comey, we will begin this line of questioning, then we'll finish it the next round. FISA and other similar related counterterrorism programs have been described even this morning as vital, critical, and indispensable to our national security. And many of us on both sides of the aisle believe FISA and similar counterterrorism programs prevent terrorist attacks and save American lives. But FISA and other surveillance programs are intentionally designed to preserve the privacy of U.S. citizens. They are intentionally designed to ensure the information is collected and used only for legitimate national security and criminal investigative purposes. There are statutory safeguards. There are warrants based on probable cause. There is a FISA court that is involved. There are audits on the back end, and we think so highly of this material. It is a felony punishable by up to 10 years in federal prison to unlawfully disseminate it. All of this was done to make sure this information gathered remains protected as it relates to U.S. citizens. The way I view it, Director Comey, the American people have an agreement with their government. We are going to give you the tools to keep us safe, even if it infringes on our privacy some. We're going to give you the tools. And government in return promises to safeguard the privacy of U.S. citizens. And when that deal is broken, it jeopardizes American trust in these surveillance programs. So let me ask you, do you agree FISA is critical to our national security?
I do.
Do you agree programs like FISA were intentionally designed to safeguard the identity of U.S. persons?
Yes, there are other important elements of it, but that's the primary goal, I believe.
It wasn't an afterthought. It wasn't an accident. These are intentional safeguards that we put in place to protect U.S. citizens. Is that correct?
Correct.
Do you agree much of what is learned from these programs is classified or otherwise legally protected?
All FISA applications, review by the court, collection by us pursuant to our FISA authority is classified.
The dissemination of which is a felony punishable by up to 10 years in prison?
Sure, dissemination, unauthorized dissemination.
Unauthorized dissemination of classified or otherwise legally protected material punishable by a felony up to 10 years in federal prison.
Yep, yes, as it should be.
All right. In January of this year, the Washington Post reported, according to a senior U.S. government official, a named U.S. citizen, and I will not use the name, a named U.S. citizen, phoned the Russian ambassador several times on December the 29th. In February of this year, the Washington Post reported nine current and former officials who were in senior positions at multiple agencies at the time of the call spoke on the condition of anonymity to discuss intelligence matters, and that officials began poring over intelligence reports, intercepted communications, and diplomatic cables. In February of this year, the New York Times reported a U.S. citizen, whose name I will not use, discusses sanctions with the Russian ambassador in a phone call, according to officials who have seen a transcript of the wiretapped conversation. And again in February of this year, the New York Times reported on a phone call involving a U.S. citizen, including significant discussions of phone records, intercepted calls, intercepted communications, and reported the NSA captured calls and then asked the FBI to collect as much information as possible. My time is up, so I will say this for this round. I thought it was against the law to disseminate classified information. Is it?
Oh, yes, sure, it's a serious crime. I'm not going to comment on those particular articles because I don't want to, in any circumstance, compound a criminal act by confirming that it was classified information. But in general, yes, it's a serious crime, and it should be, for the reasons you said.
We'll take it back up next round, Mr. Chairman.
As you know, our practice is not to confirm the existence of ongoing investigations, especially those investigations that involve classified matters. But in unusual circumstances, where it is in the public interest, it may be appropriate to do so, as Justice Department policies recognize. This is one of those circumstances. I have been authorized by the Department of Justice to confirm that the FBI, as part of our counterintelligence mission, is investigating the Russian government's efforts to interfere in the 2016 presidential election. And that includes investigating the nature of any links between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. As with any counterintelligence investigation, this will also include an assessment of whether any crimes were committed. Because it is an open, ongoing investigation and is classified, I cannot say more about what we are doing and whose conduct we are examining.
So my question, as of today, Admiral Rogers, do you have any evidence that Russia cyber actors changed vote tallies in the state of Michigan?
No, I do not, but I would highlight we're a foreign intelligence organization, not a domestic intelligence organization. So it would be fair to say we are probably not the best organization to provide a more complete answer.
How about the state of Pennsylvania?
No, sir.
The state of Wisconsin?
No, sir.
State of Florida?
No, sir.
The state of North Carolina?
No, sir.
The state of Ohio?
No, sir.
So you have no intelligence that suggests or evidence that suggests any votes were changed?
I have nothing generated by the National Security Agency, sir.
Director Comey, do you have any evidence at the FBI that any votes were changed in the states that I mentioned to Admiral Rogers?
No.
Thank you. We'll go back to, I'll yield myself 15 minutes and we'll go back to Mr. Gowdy.
Thank you, Mr. Chairman. Director Comey, you and I were discussing the felonious dissemination of classified material during the last round. Is there an exception in the law for current or former U.S. officials who request anonymity?
To release classified information?
Yes, sir.
No.
Is there an exception in the law for reporters who want to break a story?
Well, that's a harder question as to whether a reporter incurs criminal liability by publishing classified information, and one probably beyond my ken. I'm not as good a lawyer as Mr. Schiff said I used to be.
Well, I don't know about that, but the statute does use the word publish, doesn't it?
It does, but that's a question I know the Department of Justice has struggled with through administration after administration.
I know the department struggled with it, the Fourth Circuit struggled with it, lots of people have struggled with it, but you're not aware of an exception in the current dissemination of classified information statute that carves out an exception for reporters.
No, I'm not aware of anything carved out in the statute. I don't think a reporter has been prosecuted, certainly in my lifetime, though.
Well, there have been a lot of statutes at bar in this investigation for which no one's ever been prosecuted or convicted, and that does not keep people from discussing those statutes, namely the Logan Act. In theory, how would reporters know a U.S. citizen made a telephone call to an agent of foreign power?
How would they know legally?
Yes.
If it was declassified and then discussed in a judicial proceeding or a congressional hearing, something like that.
And assume none of those facts are at play, how would they know?
Someone told them who shouldn't have told them.
How would a reporter know about the existence of intercepted phone calls?
Well, same thing. In a legitimate way, through a appropriate proceeding where there's been declassification. in any other way, in an illegitimate way.
How would reporters know if a transcript existed of an intercepted communication?
Same answer. The only legitimate way would be through a proceeding, appropriate proceeding. The illegitimate way would be somebody told them who shouldn't have told them.
What does the term mask mean in the concept of FISA and other surveillance programs?
As Director Rogers explained, it's our practice, approved by the FISA court, of removing the names of U.S. persons to protect their privacy and their identity unless it hits certain exceptions. So masking means, as Mike Rogers said, I'll often see an intelligence report from NSA that will say U.S. person number 1, U.S. person number 2, U.S. person number 3, and there's no further identification on the document.
Admiral Rogers said there are 20 people within the NSA that are part of the unmasking process. How many people within the FBI are part of the unmasking process?
I don't know for sure as I sit here. Surely more, given the nature of the FBI's work. We come into contact with U.S. persons a whole lot more than the NSA does, because we may be conducting, we only conduct our operations in the United States to collect electronic surveillance, to conduct electronic surveillance. So I can find out the exact number. I don't know it as I sit here.
Well, I think, Director Comey, given the fact that you and I agree this is critical, vital, indispensable, a similar program is coming up for reauthorization this fall with a pretty strong headwind right now, it would be nice to know the universe of people who have the power to unmask a U.S. citizen's name, because that might provide something of a roadmap to investigate who might have actually disseminated a masked U.S. citizen's name.
Sure, the number is relevant, but what I hope the American people will realize is the number is important, but the culture behind it is, in fact, more important. The training, the rigor, the discipline. We are obsessive about FISA and the FBI for reasons I hope make sense to this committee, but everything that's FISA has to be labeled in such a way to warn people, this is FISA. We treat this in a special way. So we can get you the number, but I want to assure you the culture of the FBI and the NSA around how we treat U.S. person information is obsessive, and I mean that in a good way.
Director Comey, I am not arguing with you, and I do agree the culture is important, but if there are 100 people who have the ability to unmask and the knowledge of a previously masked name, then that's 100 different potential sources of investigation. And the smaller the number is, the easier your investigation is. So the number is relevant. I concede the culture is relevant. NSA, FBI, what other U.S. government agencies have the authority to unmask a U.S. citizen's name?
Well, I think all agencies that collect information pursuant to FISA have what are called standard minimization procedures, which are approved by the FISA court, that govern how they will treat U.S. person information. So I know the NSA does, I know the CIA does, obviously the FBI does. I don't know for sure beyond that.
How about the Department of how about Maine Justice?
I mean, Maine Justice, I think, does have standard minimization procedures.
All right, so that's 4. The NSA, FBI, CIA, Maine Justice. Does the White House have the authority to unmask a U.S. citizen's name?
I think other elements of the government that are consumers of our products can ask the collectors to unmask. The unmasking resides with those who collected the information. And so if Mike Rogers' folks collected something and they send it to me in a report and it says U.S. person number 1, and it's important for the FBI to know who that is, our request will go back to them. The White House can make similar requests of the FBI or of NSA, but they don't on their own collect, and so they can't on their own unmask. I got that about right?
Yeah, that's correct.
I guess what I'm getting at, Director Comey, is you say it's vital, you say it's critical, you say it's indispensable. We both know it's a threat to the reauthorization of 702 later on this fall. And oh, by the way, it's also a felony punishable by up to 10 years. So how would you begin your investigation, assuming for the sake of argument that a U.S. citizen's name appeared in the Washington Post and the New York Times unlawfully? Where would you begin that investigation?
Well, I'm not going to talk about any particular investigation.
That's why I said in theory.
You would start by figuring out, so who are the suspects? Who touched the information that you've concluded ended up unlawfully in the newspaper, and start with that universe, and then use investigative tools and techniques to see if you can eliminate people or include people as more serious suspects.
Do you know whether Director Clapper knew the name of the U.S. citizen that appeared in the New York Times and Washington Post?
can't say in this forum because, again, I don't want to confirm that there was classified information in the newspaper.
Would he have access to an unmasked name?
In some circumstances, sure, he was the Director of National Intelligence, but I'm not talking about the particular.
Would Director Brennan have access to an unmasked U.S. citizen's name?
In some circumstances, yes.
Would National Security Advisor Susan Rice have access to an unmasked U.S. citizen's name?
I think yes, in general, and any other national security advisor would, I think, as a matter of their ordinary course of their business.
Would former White House advisor Ben Rhodes have access to an unmasked U.S. citizen's name?
I don't know the answer to that.
Would former Attorney General Loretta Lynch have access to an unmasked U.S. citizen's name?
In general, yes, as would any Attorney General.
So that would also include acting AG Sally Yates?
Same answer.
Did you brief President Obama on, well, I'll just ask you, did you brief President Obama on any calls involving Michael Flynn?
I'm not going to get into either that particular case, that matter, or any conversations I had with the President, so I can't answer that.
Well, Director Comey, there's been some speculation this morning on motive. I'm not all that interested in motive. First of all, it's really hard to prove. Secondarily, you never have to prove it. But I get that people want to know. I get the jury always wants to know why. I think you and I can agree there are a couple of reasons that you would not have to unlawfully, feloniously disseminate classified material. It certainly wasn't done to help an ongoing criminal investigation because you already had the information, didn't you?
Again, I can't answer in the context of this particular matter.
How about in theory? Is there something a reporter would have access to that the head of the FBI would not?
It's hard for me to answer. I would hope not when it relates to the
I would
FBI's
hope not too, since it's part of our surveillance programs. I would hope that you had access to everything as the head of the world's premier law enforcement agency. I would hope that you had it all. So if you had it all, the motive couldn't have been to help you because you already had it. And Admiral Rogers, the motive couldn't have been to help you because you already had it. So in the universe of possible motives for the felonious dissemination of classified material, we could rule out wanting to help the intelligence communities and the law enforcement communities. Those are two motives that are gone now. That leaves some more nefarious motives. Is the investigation into the leak of classified information, has it begun yet?
I can't say because I don't want to confirm that that was classified information.
Well, I don't want to quarrel with you, Director Comey, and I do understand that you cannot ordinarily confirm or deny the existence of an investigation. But you did it this morning citing DOJ policy given the gravity of the fact pattern. Would you not agree that surveillance programs that are critical, indispensable, vital to our national security, some of which are up for reauthorization this fall, that save American lives and prevent terrorist attacks also rises to the level of important?
I think those programs are vital, and leaks of information collected pursuant to court order under those programs are terrible, and as I said in my opening statement, should be taken very, very seriously. What I don't ever want to do is compound what bad people have done and confirm something that's in the newspaper, because sometimes newspaper gets it right. There's a whole lot of wrong information allegedly about classified activities that's in the newspaper. We don't call them and correct them either. That's another big challenge, but we just don't go anywhere near it because we don't want to help and compound the offense that was committed.
I understand that, Director Comey, and I'm trying really hard not to get you to discuss the facts at bar. But some of the words that appeared in this public reporting include the word transcript, which has a very unique use in the matters that you and I are discussing this morning. That is a very unique use of that word. Wiretap has a very specific meaning. The name of a U.S. citizen that was supposed to statutorily be protected is no longer protected. So some of this reporting, let's assume 90% of it is inaccurate. That other 10% is still really, really important. And to the extent that you can rely on the dates in either the Washington Post or the New York Times, we are talking about February of this year is when the reporting first took place. So we're a month and a half or 2 months into something that you and I agree is incredibly important and also happens to be a felony. So I'm just simply asking you to assure the American people, you've already assured them you take it really seriously. Can you assure them that it is going to be investigated?
I can't, but I hope people watching know how seriously we take leaks of classified information, but I don't want to confirm it by saying that we're investigating it. And I'm sorry I have to draw that line. I just think that's the right way to be.
Well, I'm not going to argue with you, Director Comey, but it is, we're going to discuss a lot of important things today. Whether Russia attempted to influence our democratic process is incredibly important. Whether they sought to influence it is a separate analysis, incredibly important. The motive behind that interference and influence, incredibly important. Our U.S. response, incredibly important. Some of that may rise to the level of a crime, some of it does not rise to the level of a crime. One thing you and I agree on is the felonious dissemination of classified material most definitely is a crime. So I would ask you, and I understand some of the procedures that you are up against, I would humbly ask you to seek authority from whomever you need to seek authority from. Because I'm going to finish the same way I started. This is an agreement between the American people and its government. We, the American people, give certain powers to government to keep us safe. And when those powers are misused, and the motive is not criminal investigations or national security, then I'll bet you my fellow citizens are rethinking their side of the equation. Because that U.S. citizen could be them next time. It could be you. It could be me. It could be anyone until we start seriously investigating and prosecuting what Congress thought was serious enough to attach a 10-year felony to. With that, I would yield back, Mr. Chairman.
Can I just add a response to what you said? I agree with you, Mr. Gowdy. Two things folks at home should know. First, an unauthorized disclosure of FISA is an extraordinarily unusual event, so be assured we're going to take it very seriously because our trust with the American people and the federal judges that oversee our work is vital. And second, that this conversation has nothing to do with 702. Folks often mix them together. 702 is about targeting non-U.S. persons overseas. Pursuant to the FISA statute, the FBI can apply to collect electronic surveillance in the United States, but it's a different thing from 702. The conversation you and I are just having is about this, which is vital and important, but I just didn't want to leave folks confused.
Director Comey, you are 100% correct, and I am 100% correct in saying that that is a distinction that doesn't make a difference to most of the people watching television. You are exactly correct. What we are reauthorizing this fall has nothing to do with what we are discussing, other than it is another government program where the people consent to allow government to pursue certain things with the explicit promise it will be protected. So you're right, they're different. But in the eyes of people watching, it is the U.S. government officials leaking the name of a U.S. citizen, and if it can happen here, it may happen there. Trust me, you and I both want to see it reauthorized. It is in jeopardy if we don't get this resolved.
To me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails, correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails, correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. It's a low-level guy, and you're trying to move up in the chain, you might think about it differently.
Well, he lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
Oh, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Gambetta?
Gambetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay. Everything. Do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken?
Yeah.
I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department and my colleague Mr. Gowdy here notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with bleach bits, so the FBI didn't review that. After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with bleach bit, so the FBI didn't review that. And also after the subpoena, backups of the Platte River server were manually deleted. Now, Director, hopefully that list is substantially accurate because it comes from your own documents. My question to you is this. Any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice. And to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton.
These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay, for the record, yes, the Department of Justice does not grant immunity without checking with federal law enforcement to see whether it will impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were granting handing out like candy, according to some, immunity, did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Gambetta. You gave them immunity from destruction.
Director, in your opening comments, you said this was an unusual case. I would say that's the understatement of the year. Husband of the subject meets with the Attorney General 3 days before Secretary Clinton is interviewed by the FBI. 9 people get to sit in with Secretary Clinton during that interview. One of those was her Chief of Staff, Cheryl Mills, who was the subject of the investigation. 5 people get some kind of immunity. 5 people get some kind of immunity, yet no one is prosecuted. 3 of those people who get immunity take the 5th in front of Congress, and one of them doesn't even bother to show up when he's subpoenaed. Supposed to have been at that very chair you're sitting at. And of course, the Attorney General announces that she's going to follow your recommendations, even though she doesn't know what those recommendations are, the only time she's ever done that. So, of course, this was unusual. We've never seen anything like this, which sort of brings me to the post. I'd like to put up the post that some have talked about, which is the post by Mr. Gambetta on Reddit. And you said earlier that you don't know if you examined this during your investigation, so let's examine it now. I need to strip out a VIP's address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Now, Director, when I hear the term strip out email address, I think of somebody's trying to hide something, somebody's trying to cover up something, and it sort of raises an important question from these 2 sentences. Who's the they who wants something hid, and who's the VIP who also wants something hid? Director Comey, is it likely the VIP well, actually not just a VIP, it's a very, very important person according to Mr. Gambetta. Is it likely that that person is Secretary Clinton?
Yes, sure.
Okay, and is it also likely that the they refers to her Secretary Clinton's staff and specifically Cheryl Mills?
I don't know that. Either her lawyers or some staff that had tasked him with the production.
So one other thing that's important on that, if we could put that back up, one other thing that's important is the date. The date at the top says July 24th, 2014. So whenever I see a date, I'm sure you do the same thing, I always look at what's happening about that same time frame, what may have happened directly before that, and maybe directly after that. So I went back to your reports that you guys had given to us. The first report back last month, August 18th, 2016, page 15. On page 15 it says, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. State Department gives Cheryl Mills a heads up that she's got to go round up all of Secretary Clinton's email. On that same page it says the House Select Committee on Benghazi had reached an agreement with the State Department regarding production of documents on July 23rd, 2014, just the day before, which I find kind of interesting. Then from your report that we got just last week, after reviewing several documents dated in and around July 23rd, 2014, Paul Gambetta had a conversation with Cheryl Mills, and after reviewing a July 24th, there's that date again, 2014 email from Brian Pagliano, Paul Gambetta explained Cheryl Mills was concerned Clinton's then current email address would be disclosed publicly. So, sure looks to me like it's Secretary Clinton, as you said, but also that it's Cheryl Mills and Brian Pagliano who are urging Mr. Gambetta to cover this stuff up. You agree?
From what you read, it sure sounds like they're trying to figure out a way to strip out the actual email address from what they produce.
Well, they're actually trying to strip it all out. PST file, everything. Here's the takeaway in my mind. Mills gets a heads up, Cheryl Mills gets a heads up in midsummer of 2014. July 23rd, the day before Mr. Gambetta's Reddit post, the Benghazi Committee and the State Department reached an agreement on production of documents. Cheryl Mills has a conversation with Paul Gambetta. He goes on Reddit then and tries to figure out how he can get rid of all this email. Even though he's not successful then, he has to do it later down the road with BleachBit. And then the clincher. The clincher. Just last week, he's going online and trying to delete these Reddit posts. He's trying to cover up his tracks. He's trying to cover up the cover-up.
For this reason, intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked, and whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously that's on the face of the statute itself, then you need to consider, so who else has been prosecuted and in what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way to
treated
prove,
other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand. Because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Was this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
I'm sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, depending on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit on these records.
Sure. That's why the guy wouldn't talk to us without immunity.
And so when you got immunity, what did you learn?
We learned that no one had directed him to do that, that he had done it.
You really think that he just did this by himself?
I think his account, again, I never affirmatively believe anybody except my wife, but the question is, do I have evidence to disbelieve him? And I don't. His account is credible, that he was told to do it in 2014, screwed up and didn't do it, panicked when he realized he hadn't, and then raced back in and did it after Congress asked for the records and the New York Times wrote about them. That was his shit moment. And that was credible. Again, I don't believe people, but we did not have evidence to disbelieve that and establish someone told him to do that. No email, no phone call, nothing. The hope was, if he'd been told to do that, that'd be a great piece of evidence. If we give him immunity, maybe he'll tell us, so-and-so told me to, so-and-so asked me to, and then we're working up the chain.
But he did indeed destroy federal records, and he was told at some point to do this, correct? Who told him to do that initially? When he was supposed to do it in December, and he didn't do it. Who told him to do that?
One of Secretary Clinton's staff members, I can't remember sitting here, we know that. One of her lawyers might have been Cheryl Mills. Someone on the team said, we don't need those emails anymore, get rid of the archive file.
This is what's unbelievable about this, because there's classified information, there are federal records that were indeed destroyed. And that's just the fact pattern. Let's go back to this. Here's the other thing that I draw to your attention that is new. September 15th of this year, I issued a subpoena from the Oversight and Government Reform Committee. On these Reddit posts, 4 days later, they were destroyed or taken down. They were deleted. I would hope the FBI would take that into consideration. Again, we're trying under a properly issued subpoena to get to this information. Let's go to Heather Mills real quick. How does in the 2016 interview with Cheryl Mills, she says, quote, Mills did not learn, in the interview report, the interview summary from the FBI, Mills did not learn Clinton was using a private email server until after Clinton's tenure. Back, also, you have this interview with Mr. Pagliano, who said he approached, quote, Pagliano then approached Cheryl Mills in her office and relayed a State Department employee's concerns regarding federal records retention and the use of a private server. Pagliano remembers Mills replying that former secretaries of state had done similar things, to include Colin Powell. It goes then on to a page 10, and this is what I don't understand. The FBI writes, Clinton's immediate aides, to include Mills, Abedin, Sullivan, and a redacted name, told the FBI they were unaware of the existence of a private server until after Clinton's tenure at State, or when it became public knowledge. But if you look back at the email from Heather Mills, if you go back to 2010, this is to Justin Cooper, okay? Mills to Cooper, who does not, he works for Clinton's, he doesn't work for the State Department. FYI, HRC email coming back, is server okay? Cooper writes back, you are funny, we're on the same server. She knew there was a server. When there was a problem with Hillary Rodham Clinton's emails, what did they do? She called the person who has no background in this, who's not a State Department employee, no security clearance, and then tells the FBI, well, I never knew about that. But there's direct evidence that contradicts this. How do you come to that conclusion and write that in the summary statement that she had no knowledge of this?
That's a question.
Yes.
The time of the gentleman has expired, but the
Director will answer the question.
I don't remember exactly sitting here. Having done many investigations myself, there's always conflicting recollections of facts, some of which are central, some of which are peripheral. I don't remember sitting here about that one.
But a majority of the American people have come to the conclusion that Hillary Clinton is not honest and cannot be trusted. It's about 2 to 1 who say that she's dishonest. In the latest Quinnipiac poll, for example, the question being, would you say that Hillary Clinton is honest or not? 65% said no, and only 32% said yes, she is honest. Republicans and Democrats, not surprisingly, were overwhelmingly one way or the other, but independents, 80% of them said nope, she's not honest, and only 19% of them said she is.
Saying that that is a distinction that doesn't make a difference to most of the people watching television. You are exactly correct. What we are reauthorizing this fall has nothing to do with what we are discussing, other than it is another government program where the people consent to allow government to pursue certain things with the explicit promise it will be protected. So you're right, they're different. But in the eyes of people watching, it is the U.S. government officials leaking the name of a U.S. citizen, and if it can happen here, it may happen there. Trust me, you and I both want to see it reauthorized. It is in jeopardy if we don't get this resolved.
Mr. Gowdy is recognized.
Thank you, Mr. Chairman. Director Comey, we will begin this line of questioning, then we'll finish it the next round. FISA and other similar related counterterrorism programs have been described even this morning as vital, critical, and indispensable to our national security. And many of us on both sides of the aisle believe FISA and similar counterterrorism programs prevent terrorist attacks and save American lives. But FISA and other surveillance programs are intentionally designed to preserve the privacy of U.S. citizens. They are intentionally designed to ensure the information is collected and used only for legitimate national security and criminal investigative purposes. There are statutory safeguards. There are warrants based on probable cause. There is a FISA.
The Russian government's efforts to interfere in the 2016 presidential election. And that includes investigating the nature of any links between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. As with any counterintelligence investigation, this will also include an assessment of whether any crimes were committed. Because it is an open, ongoing investigation and is classified, I cannot say more about what we are doing and whose conduct we are examining.
So my question, as of today, Admiral Rogers, do you have any evidence that Russia cyber actors changed vote tallies in the state of Michigan?
No, I do not, but I would highlight we're a foreign intelligence organization, not a domestic intelligence organization. So it would be fair to say we are probably not the best organization to provide a more complete answer.
How about the state of Pennsylvania?
No, sir.
The state of Wisconsin?
No, sir.
State of Florida?
No, sir.
The state of North Carolina?
No, sir.
The state of Ohio?
No, sir.
So you have no intelligence that suggests, or evidence that suggests any votes were changed?
I have nothing generated by the National Security Agency, sir.
Director Comey, do you have any evidence at the FBI that any votes were changed in the states that I mentioned to Admiral Rogers?
No.
Thank you. We'll go back to, I'll yield myself 15 minutes and we'll go back to Mr. Gowdy.
Thank you, Mr. Chairman. Director Comey, you and I were just
Review by the court, collection by us pursuant to our FISA authority is classified.
the dissemination of which is a felony punishable by up to 10 years in prison.
Sure, dissemination, unauthorized dissemination.
Unauthorized dissemination of classified or otherwise legally protected material punishable by a felony up to 10 years in federal prison.
Yep, yes, as it should be.
All right. In January of this year, the Washington Post reported, according to a senior U.S. government official, a named U.S. citizen, and I will not use the name, a named U.S. citizen, phoned the Russian ambassador several times on December the 29th. In February of this year, the Washington Post reported nine current and former officials who were in senior positions at multiple agencies at the time of the call spoke on the condition of anonymity to discuss intelligence matters, and that officials began poring over intelligence reports, intercepted communications, and diplomatic cables. In February of this year, the New York Times reported a U.S. citizen, whose name I will not use, discusses sanctions with the Russian ambassador in a phone call, according to officials who have seen a transcript of the wire report that is involved. There are audits on the back end, and we think so highly of this material. It is a felony punishable by up to 10 years in federal prison to unlawfully disseminate it. All of this was done to make sure this information gathered remains protected as it relates to U.S. citizens. The way I view it, Director Comey, the American people have an agreement with their government. We are going to give you the tools to keep us safe, even if it infringes on our privacy some. We're going to give you the tools. And government in return promises to safeguard the privacy of U.S. citizens. And when that deal is broken, it jeopardizes American trust in these surveillance programs. So let me ask you, do you agree FISA is critical to our national security?
I do.
Do you agree programs like FISA were intentionally designed to safeguard the identity of U.S. persons?
Yes, there are other important elements of it, but that's the primary goal, I believe.
It wasn't an afterthought. It wasn't an accident. These are intentional safeguards that we put in place to protect U.S. citizens. Is that correct?
Correct.
Do you agree much of what is learned from these programs is classified or otherwise legally protected?
All FISA applications.
Tapped conversation. And again, in February of this year, the New York Times reported on a phone call involving a U.S. citizen, including significant discussions of phone records, intercepted calls, intercepted communications, and reported the NSA captured calls and then asked the FBI to collect as much information as possible. My time is up, so I will say this for this round. I thought it was against the law to disseminate classified information. Is it?
Oh, yes, sure, it's a serious crime. I'm not going to comment on those particular articles because I don't want to, in any circumstance, compound a criminal act by confirming that it was classified information. But in general, yes, it's a serious crime, and it should be, for the reasons you said.
We'll take it back up next round, Mr. Chairman.
As you know, our practice is not to confirm the existence of ongoing investigations, especially those investigations that involve classified matters. But in unusual circumstances, where it is in the public interest, it may be appropriate to do so, as Justice Department policies recognize. This is one of those circumstances. I have been authorized by the Department of Justice to confirm that the FBI, as part of our counterintelligence mission, is investigating